Next case for argument is Ronald RUBLE, MARSHAYEAGER et al. Versus GRASSO. You may. Counsel for both parties ready to proceed?
Yes, Your Honor. May it please the Court, Michael Walker on behalf of the appellants, and I'd like to reserve 5 minutes for rebuttal.
Okay.
Your Honor, in 1993, a group of individuals who owned property in an area known as the Blue Ridge Flight Park, which is represented graphically on our exhibit that we've set up today, set out to create a formal easement for a runway, or to create an airstrip for a runway. They executed documents. They executed written easement documents. Those easement documents contained a detailed meets and bounds description of where that runway was. The documents were executed without any substantial objections or any substantial questions on behalf of any of the 12 parties that created the airstrip. The parties that created the airstrip were essentially the same parties who are property owners around the airstrip. And the easements, the way that the easement was set up, is that it used the existing property line as the eastern boundary of the airstrip.
So when you say that the easement reflected where that runway was, you don't mean where it was on the ground?
Well, that's a good point. Essentially, if I can approach the document, I think I can show you. The record is clear that up until the present day, the use of the airstrip never extended any further than approximately lots 7 and 8, and probably using 378 and 377 as a turnaround area. So the actual runway that was in use was no further north than these lots here.
Is that about 2,800 feet, something?
Approximately 2,800 feet. The entire runway itself is over 3,300 feet. Now, at the time that this was created, I think I would concede that there may not have been a total convergence between the active runway and the area that was designated as the easement area. But you can see from the diagram that the area that contained the easement also contained probably about 95% of the so-called active runway, the runway that was being used. Now, you have to understand this is a grass strip airway. There is no tarmac. There is no concrete here. So the runway itself is not defined in terms of a specific construction. It is a grass strip that people have used historically to take off aircraft. Now, the important point there is, at the time that the document was executed and at the time these documents were made, the historical, so-called historical runway was contained basically within the easement, and the northern half was not improved and was not in use as a runway. And really the dispute arose at a point in time when the people on the north end of the runway began to improve, or intended to improve, the runway in order to make use of the entire 3,350 feet of airstrip. And that's when this dispute arose. Now, what happened is the purchaser, Mr. Ronald RUBLE, who purchased lots towards the north end of the airstrip, became aware that aircraft were trespassing outside of the area of the easement. And he objected to that, and suit was filed. And the suit that was filed was essentially one to quiet title and to essentially establish who had rights in the existing airstrip. There was no claim of reformation at that point in time. In fact,
when did the part of the runway above 2,800 feet start being used?
It isn't, and it isn't to this day. It's never been used. It has been improved.
I thought you just said that this all began when RUBLE discovered that people were using
This area of the airstrip was being approximately, I think the testimony was approximately halfway north into lot 378. They were using this as a turnaround area. So it was in use at some point, not throughout the entire history of the airstrip, but at some point when he purchased this property, this area was being used about halfway into this property.
Let me ask you, if you're referencing to a name on that thing, this judge is a little bit older, and I can't see those names or read those names, so you're going to have to tell me what those names are if you're referencing a particular lot.
I'm sorry, this is lot 378, which was purchased by Ronald RUBLE, who was one of the appellants. When he purchased this lot, like I said, this area of the airstrip was being improved. What they do is they look down clay substance, harden the ground to allow aircraft to take off there. And this area of the airstrip has been essentially worked on, although it's not completely all the way down here, but it's been worked on up here. And that was in this dispute basically was. The lawsuit that was filed to quiet title and to establish the rights and the use of the airstrip. And as I said, there was no claim at that point in time that there was any mistake in these written documents. All of the appellants, which I represent, all purchased property long after this easement was created. And they all purchased property long after these documents were filed in the county record, in the county property record, establishing where the easement was. They all testified that they relied upon those documents when they purchased their property, and that they knew where the easement was that they intended to use. Now, at this point in time, it was after the close of evidence at trial, and during closing argument, that reformation was brought up for the first time.
You haven't raised on appeal an issue that the judge abused his discretion by allowing an amendment, correct?
No.
I mean, that's not an issue.
It isn't a direct issue, but it helps to explain why there is this lack of evidence and this lack of appropriate parties to this action. Because if you understand, reformation is an extraordinary remedy. The law presumes that a written document expresses the intent of the parties to it. And if you're going to reform a document, if you're going to rewrite a document, the purpose of doing that is to cause the document to reflect the intent of the original parties, all of the original parties to that document. Not some of them. A unilateral mistake is not enough. You have to have the same mutual mistake between all of the parties. So from a purely jurisprudential standpoint, what the court had to find, and what the court found by implication, is that all 12 of those original parties to this easement creation intended to create the easement that is represented by the yellow strip on this document. Part of the problem is that yellow strip, first of all, extends obviously 1,000 feet further north than everyone agrees the runway is being used.
Rule testified that every one of the original parties, because he was in meetings with all of them, thought that the easement described the historical runway. There was other testimony from people who were the original parties that said that that was also their understanding. The only person that contradicted that was Powell, and my question is, why couldn't the trial judge who was there to view the credibility of the witnesses just determine that Powell wasn't credible and find, based on that testimony, that everybody understood that the easement in the documents reflected the historical runway? Why isn't that sufficient to meet the burden that you're complaining wasn't met?
Well, first of all, I think if you review that testimony carefully, it's not quite that clear. What he testified to was essentially that he believed that the easement was preserving the existing runway.
And he said that that's what everybody understood.
Correct. Well, he said that, he may have said that.
He did say it.
And if he said that, Your Honor, is that sufficient evidence to overcome the extraordinary evidentiary burden upon the reformation of a written document? The case law says no. The case law says that if you're going to reform a deed, if you're going to reform a contract, you need to have all of the parties to that document present.
Now, what case says that you have to include every party that was originally there? What the case law says is that you have to include everyone that has a current legal or equitable interest, but folks who are obviously perhaps deceased or sold their property long ago wouldn't have any legal or equitable interest in the action.
Are you referring to the Sean Ray Investments case? I believe in the Sean Ray Investments case, the original grantors and grantees under that title were not the current owners of the property. It was the previous owners of the property. That was a reformation of a deed case. And their finding was that the original parties to that deed were necessary parties to the action to reform that deed. In other words, you had to have evidence from the people that formed the written instrument as to what their intent was in order to reform the deed against them. Subsequent purchasers cannot say what the original signatories meant to do. Now, to the extent that you can read the testimony of Warren Bruhl as attempting to speak upon or
You had Bruhl, Umscheid, and Moritz, all of whom were original parties, correct?
Yes. There were 4 witnesses who were original parties to the easements. Clifford Umscheid's trial testimony is not the same as his affidavit, which is cited in the brief in the answer brief. His trial testimony was to the effect that he didn't know where the easement was at the time that he signed it. But in any event, there are additional problems with this case, other than just the lack of evidence and the lack of the necessary parties. You also have to deal with the problem of the bona fide purchasers, which my clients all represent bona fide purchasers who bought their property in reliance on the public record. Now, the response that you're going to get from the appellee is essentially, well, if you went out and surveyed the property and you went out and looked at the active airstrip, you would be able to determine that there was a discrepancy. Our answer to that is very simple. Simply determine, even if that's true, determining that there is a discrepancy between the runway that's being used and the easement does not put a person on notice that the original 12 signatories to that easement all intended to create a completely different runway. Now, and I was going to tell you before, the runway easement that the court used is a 2001 survey. That is not a contemporaneous document. That is not a contemporaneous property description from 1993. So what the court has done is to substitute the survey that was done in 1993 of the appropriate easement and substitute in place of that a 2001 survey. So that's part of the problem. But you still have to deal with the bona fide purchaser status. The court doesn't attempt to deal with the bona fide purchaser status of Vernon Kepler. With regard to the other 3 appellants, the court simply decides, well, they knew or they had some sort of constructive knowledge when they purchased their property. With regard to Iron Cross Farms, who is represented by Robert Hahn, he testified very clearly, and we've cited his testimony in the record, that he had no idea there was a discrepancy until long after he had purchased his property. In fact, the only appellant that said that they knew that there was a discrepancy was RONALD RUBLE. And his testimony was that he knew that the aircraft were using an area that deviated from the easement, but he also knew that they were improving the north end of the runway in order to move the traffic back into the appropriate easement.
You would at least agree that any purchaser would be on notice that there was a potential problem, and that if they looked, they would see that the described easement was not the same as the runway that was actually being used and had been used for a long time.
I would concede that with an appropriate survey and an appropriate examination of the ground, you would probably have determined that the aircraft were outside, using an area somewhat outside of the easement. But there's a point that has to be made in connection with that. Part of what's wrong with the argument that they're making, that we should have figured out what they meant to do, is that if it was so obvious to us, if it should have been so obvious to us that we had constructive knowledge of their intent, then why wasn't it obvious to them when they executed the documents and filed them into the public record? Reformation is an equitable principle. The proponent of reformation has to have higher equities than the person they're reforming against. So who has the better equities? The people who purchased 10 years after the fact, relying on the public record, or the people who filed these documents in the public record, created the easement, and now are telling the court, well, that's not really what we meant to do. So there's no way to resolve the problem with not having the necessary parties present at the trial. You can't adjudicate the intent of 12 people based upon the statement of one person, well, that's what everybody thought. That's not sufficiently conclusive, substantial evidence to meet that heightened evidentiary burden. There's one other point that I want to make. I'm getting close to my time that I wanted to reserve. There's one other point that has to be made. If I can approach the document. The easement document defines access to the runway by abutting lots, touching lots. So in other words, the document says the only lots that touch or abut the runway come with an easement in effect. By moving the runway to this area over here, the court, as you can see, you've got this lot all the way north, you do not abut the runway. These lots, this is the 800-pound gorilla in the corner. It cannot be explained away. The court order gives easement rights to non-abutting lots when the easement document defines access to the runway only according to lots that abut the runway. This points out the fallacy in what the court did. This cannot be the intent of the original parties. And I'd like to reserve my remaining time. Thank you.
Good morning. May it please the court. I'm Daniel Webster representing the appellees, which are identified in our brief. This was a difficult case for the trial judge. You've got two, or actually more, fighting sides over what happened and what happened a long time ago. The trial judge listened to 3 days of testimony. He made a very detailed ruling with a great number of specifics, dealt with the issue of reformation in detail. As the courts pointed out, there's been no challenge to his discretion in granting the motion to amend to conform with the evidence. And what we have is the situation where, based on this exhibit, you can see, if I may approach the exhibit, we have historical runway. This was the historical licensed runway. We have a FDOT license, it's an evidence, for this yellow runway strip here, and it didn't have many, many years. It was that way with all of the appellants purchased their lot. And it's clear that there is a discrepancy between the easement area of the easement document and the historical licensed runway. And the problem with the case was when RUBLE purchased it and then dumped a pile of dirt and debris blocking the runway. And so there was a suit, a counterclaim. They were ordered to remove the obstruction to clear the runway because of interference with the use of the runway. It has been historically used and licensed for 15 years at the time. With respect to the arguments, and I'll just walk through.
Just ask, am I correct that there's evidence in the record that if the runway is moved to the easement location that everybody could actually lose the runway and that it would no longer be it's a non-conforming use under the zoning code, and if you move it, you lose that use?
Absolutely.
Is that an appropriate, equitable consideration for the judge to consider?
Absolutely. And another exhibit which was introduced was Amendment 56. I need to approach a little closer to show you this. This blow-up shows and addresses that problem. The hash area is the area that was under the zoning ordinance license for runway. And when you look at the historical runway, it is within that area. And when you look at the easement area, it encroaches outside of that. The zoning ordinance is very clear. If you attempt to relocate a non-conforming use, you lose it. You don't have the right to do it. And there's specific finding by the trial court to that effect relative to the historical runway. The argument that the courts pointed out Mr. Powell's testimony, which the court addressed specifically. There was 15 witnesses testifying in this case. All were consistent with respect to a mistake, except for Mr. Powell. The trial court dealt with that directly. And if you actually even look at the trial court's discussion and questions during closing arguments, he had concerns about Mr. Powell's credibility and the fact that Mr. Powell took an action that said, We didn't mean to include the east siders, but he sold property on the lots on the east side to people with airport usage. And so the trial court correctly, I think, disregarded Mr. Powell's contradictory testimony. With respect to whether or not all the proper parties were in this case, I think the courts pointed out in the Liverpool decision addresses that in a reformation suit, all persons having legal or equitable interest in the subject matter should be made parties. All parties with a legal or equitable interest relative to that runway were parties. When I got involved in the case, which was midway through, and the defendant, Exhibit 43, which was a notebook with all of the title documentation and information on all the property owners, was introduced into evidence, there was no question as to whether or not all the parties were properly there. And furthermore, with respect to that issue, it wasn't even raised at the trial level. There was no assertion at the trial level that you don't have all the proper, necessary, or indispensable parties. It was never made, and therefore it was waived. But as a matter of law and fact by the trial court, all the parties with a legal or equitable interest were parties. They want us to name the deceased parties, or the parties which had sold their property. That is absolutely absurd. With respect to the BFP issue, the BFP issue, I think, has been dealt with very clearly. The case law says you can't bury your head in the sand. Okay? They can't act like an ostrich when they buy this property. Mr. RUBLE himself clearly testified that it was obvious. All you had to do was go out there, and you could see that the runway actually being used, and this is now, and he bought 12 years after the easement agreements, that the runway actually being used was not the easement area within the easement documents. It was obvious. It was obvious to Mr. RUBLE. It was obvious to everyone. They can't bury their head in the sand and pretend that they don't know that something exists. And so therefore, none of the appellants can be a BFP. Because if one had knowledge or was on notice of an implied knowledge because it was so obvious, all you had to do was go look at it. All were. You couldn't just look at your property and say, well, my property doesn't even have a runway being used on it. You've got to look at the entirety of where you want to claim an interest. If you look at who are the appellants, Iron Cross Farms up here, they're an appellant. RUBLE right here is an appellant. The Pepper down here, he's an appellant. But if you look at him, he's probably one of the few, if not the only one, that has a fully integrated situation where the historic easement is the same as the easement agreement. We have a situation where all they had to do was come out like Mr. RUBLE could do and look in the top. When you look at Mr. RUBLE's property in virtually the entirety of that historical runway is outside of the easement area. And the testimony is obvious. With respect to the late argued point which was raised for the first time in their reply, actually they raised 3 brand new issues in their reply brief, that the non-abutting lots, somehow this affects the rights of the parties because the judge made a mistake and it's not possible to have a situation where you've now taken, the judge said that all these lots, I would refer to probably east side, or those big issues of trial. They were arguing that the east siders did not have rights at all. Probably because they did have rights. With the exception of this lot 377, because the census that we didn't participate in, we showed no interest in protecting theirs. So, and they're not a party of the original easement agreement. If you look at, their argument is that starting at the point of, I guess it would be RUBLE where they're concerned about the issue that the east side lots not have rights because they know about the easement. That's growing because lots 7 and 8 are both owned by Mr. Aragino. rights of abutting the new reformed easement area regardless. Mr. Bowler House, 344 and 343 will have rights regardless. Iron Cross will have rights regardless. It's a red herring. It means nothing. Because these people, if besides the fact that Charles has rules of matter of reformation that they intended for all these east side lots that were 377 to have rights and have rights under it, the easement agreement was poorly written. And what did it say? It didn't say we're giving you rights to an easement for that property or that property. It said if you own property abutting the easement, you have rights. Well, all these lots which they assert were not co-bound, and they wanted to segregate those lots, which nobody bothered to do. They could simply sell off, for example, Iron Cross could sell off lot 296 together with a portion of lot 295 to a lot to make sure that he had rights to the reformed east area. That argument, I think, has no merit whatsoever. With respect to the arguments as who has the equities, the trial judge weighed the equities. And the equities he found were, let's do what everybody intended to do back in the early 1990s. Let's correct this mistake, and let's avoid a whole bunch of problems and a whole bunch of hardship. For example, if we don't have reformation, Mr. who is right down here near the bottom, he did not receive easement rights for Mr. Aragon's property. So he's out. He can't transact Mr. Aragon's property. We also have a situation with Mr. Sunshine, who is the plaintiff below, that now we're going to relocate the houses right here. We're going to relocate the runway within the edit side of the area within 10 feet of the front porch. So we're going to put it extremely close to the house. And the problem was weighed all that off. And considered all that, considered all the fights and disputes and all kinds of motions for injunction that went on at the trial, and said, look, the overwhelming evidence is that everybody intended for the historical easement to be the easement area, and that's what we're going to have happen. And the way that you've used it for the last 12 plus years, plus all the 30 years of history before that, we're going to let all of you who purchased out there and knew where the runway was, because it was obvious where the runway was, continue to use the runway as it has always been used. It's really that simple. And just simply be happy to answer any questions.
Thank you very much.
Thank you.
To briefly respond, there's approximately 3 points that I'd like to make. As I indicated earlier, the response that we get on the bona fide purchaser status argument is very simple. The response that you get from the appellees in this case is, well, it was obvious, it was perfectly obvious to everybody that there was this discrepancy, and therefore my clients must have known that there was a mistake in those written easements. And I'll reiterate what I said before. They cannot have it both ways. If it was so obvious that my clients are charged constructively with their knowledge of their intent, then how did they execute these documents and file them in the public record without realizing that the documents didn't do what they now say they intended to do? It does not make any sense. What's good for the goose is good for the gander. If it was obvious to us when we purchased our property 10 years later, it was that much more obvious to them when they created the easement documents. The equities weigh in favor of my clients and not in favor of the appellees on that point. And they cannot be stripped of their bona fide purchaser status by this rather cavalier argument that, well, it was just obvious to anybody that went out there that there was a mistake. If it was that obvious, it was obvious to everybody. They're the ones that created the easement documents. The second thing that I'd like to address, the problem with these lots abutting the airstrip, I'm afraid the appellees misapprehend what the argument is there. I'm not saying that there are not practical solutions if their clients want to sell off their property and put new easements across other property in order to access the runway. That is not the point at all. The point is that the easement documents state in plain English, this easement and the rights hereunder shall not be assignable by grantee except as an appurtenance to the property of the grantee which abuts the airstrip. The property that the court has granted easements to on the east side no longer abuts the airstrip. So if the original intent was to put the airstrip in the so-called historical area, then there was no intent to grant easement rights to those lots on the east side of the property line. You cannot have it both ways. If they got an easement, it's because they abut the airstrip. If they don't abut the airstrip, they don't have an easement. It's as simple as that. And the point that I'm making with that is that the original easement was created to run along the property line. That's obvious. It was created that way so that they could define the access to the runway according to abutting lots, and so that all of the surrounding lots would abut the airstrip and could therefore have access to the runway. So the evidence, it's simply more evidence that there was a fallacy when the court moved the airstrip to a new location outside of the deeded easement. This argument that the county is somehow going to take away the airstrip is a red herring. The county was not a party to this lawsuit. There is no substantial evidence. There is nothing to support the allegation that the county is going to strip these people of their airstrip rights. The bottom line is, if there is a discrepancy between the deeded easement and the property map or the property zoning map of the county, then there's a problem with the zoning map that can be corrected. That is not for this court. It's not an issue before this court. And the bottom line is, even if, let's assume arguendo, that if we put this airstrip back into the deeded easement, it's all going to get shut down and nobody's going to be able to use it. That fact would not give anybody the right to take property from my clients that they did not give and which was not part of that easement when they purchased their property. What do we say to Mr. RUBLE, who now loses essentially the beneficial use of his entire lot because the airstrip has been moved to the west and now bisects his lot? What do we say to Robert Hahn, the owner of Iron Cross Farms, who built his barn in reliance on the location of the easement, and now has a barn sitting on the airstrip?
Your time's expired. Thank you very much.
Thank you, Your Honor.